Okay, good evening to you all and welcome you all for my today's presentation on central state relations in India, administrative aspects. So in the last webinar, we have conducted we have seen the financial relations and administrative relations mostly. Actually, central state relation in India is a very important topic for the students, those who are pursuing UG and post-graduation programs, and also for civil service and IES exam. You will find at least one question from the central state relations. Okay. As far as the central state in India is concerned, as far as the administrative aspects are concerned, the Constitution of India facilitates administrative relations of the center with various Indian states. You'll find administrative relation between the union government, that is central government, and various states. The center's executive authority is significantly enough to spread across the entire nation. So here we can observe the union government, that is central government's executive authority, is significantly enough to spread across the entire nation. Besides, the central government gives instructions to states regarding their execution of power in certain areas. So I repeat, the central government gives instructions to states regarding their execution of power in certain areas. So the union government, state administrative relations governed by constitutional provisions states the roles and responsibilities of union government and state governments in administrative matters. So this kind of relation between the union government and the state government foster coordination. So the coordination can be enhanced between the union government and state government, cooperation and effective governance, ensuring smooth functioning of the federal structure in India. So in the federal structure, the relations between the union government and state governments are required to be strengthened. So it should foster, the relations should foster coordination, cooperation, and efficiency and effective governance. Article 256 to 263. Article 256 to 263, Part 11 of the Constitution deal with administrative relation between the center and the state. The executive powers of the union government extends to all the subjects on which Parliament can make laws. First, again, I repeat, executive powers of the union government. So union government will have some executive powers. These powers can be extended to all the subjects on which Parliament can make laws. The states also exercises executive powers conformity with the laws made by the Union Parliament. The administrative cooperation between the center and the states. So from this PPT, just you can understand that disagreements are complaints. Disagreements are complaints means sometimes you observe the river water sharing of river water, dispute between two states or three states. This is one of the common problem in India. So the disagreements or complaints can arise pertaining to river waters among the states. As I mentioned, you will find between the two states or three states with regard to sharing of the river water, their usage, distribution or control. The adjudication of such disagreements or complaints shall take place by the parliament. Number two, an interstate council can be created by the president. President sometimes he will create interstate council also to resolve the dispute between the two states. So an interstate council can be created by the president for the purpose of researching and discussing mutual interest topics between the center and Union states. So sometimes there will be some topics which would help both the central government and state governments. So in such cases, the president will set up one interstate council. That interstate council take care of the topics that are that interstate council discusses mutual interest topics between center and the Indian states. This processes to the public acts, records, and judicial process of both state and central shall be granted full faith and credit across the entirety of the nation. The Parliament shall enjoy the authoritative power to appoint an appropriate authority. So generally, you know that Parliament has some power to appoint an appropriate authority for the carrying out of constitutional provisions. So constitutional provisions are required to be safeguarded. So in order to safeguard, in order to protect the constitutional provisions, the Parliament can set up the parliamentary authority for carrying out of constitutional provisions pertaining to interstate intercourse, commerce, and trade. So the matters related to some states, between the states, related to commerce and trade. So to discuss the matters related to commerce and trade and other important constitutional provisions, the Parliament can appoint one appropriate authority. The next one, central government will have some control over the state legislation. As a whole, now if you observe the entire administrative aspects, administrative relation between union and the state government, you will find more executive authority lies with the central government only. And the state government also will have certain powers in case of certain important matters, but central government, that is union government, control over the state legislation in various ways, including building and maintaining network in the state, building and maintaining communication networks in the states. Number two, providing suitable facilities for students from linguistic minority groups to receive primary education in their native language. See, for example, there are some constitutional provisions are protecting the minority groups. So minority groups can receive their primary education in their native language. So we have been observing, for example, Urdu, they can study in their primary education can be pursued by the religious, some of the religious groups in Urdu also. And developing and implementing specific programs for the welfare of scheduled tribes in the states. So central government will direct the state governments to take certain for the welfare of scheduled tribe groups in the state, ST group people in the state. And at the same time, applying coercive measures outlined in Article 365 of the Constitution when necessary to enforce the central directions. So sometimes the union government apply coercive measures outlined in Article 365 of the Constitution if it is required, it is necessary to enforce the central directions. And the distribution of executive powers are concerned. The executive powers of union covers the entire country. Executive powers of the union, that is central government, covers the entire country. The executive powers of the state government extends to matters within the state's legislature jurisdiction. Within the state legislature jurisdiction, the state government will enjoy some executive powers, but central government executive powers will be extended to the entire country. And center's executive power extended to matters listed in the union list. You are aware of the union list, state list, and concurrent list. So center's executive power extended to matters listed in the union list. The states have executive power over matters listed in the state list. The central government executive power includes exercising authority, jurisdiction, and rights conferred by agreements and treaties. When both the parliament and state legislature have legislative power, the executive power belongs to the states. Once again, I repeat, when both the parliament and state legislature have legislative power, both have legislative powers, the executive powers belongs to states. This holds good except in cases where a constitutional provisions explicitly places it with the union. The next one, All India Services and Administrative Relations. You know some of the All India Services, that is Indian Administrative Service, IAS, Indian Police Service, and Indian Forest Service. An important aspect of administrative relation between union government and the state government is role of All India Services. This is one of the important relation between the union government and the state government. IAS, IPS, and Indian Forest Service. These services are jointly managed by the central government and state government, jointly managed, ensuring that administrative machinery functions uniformly across the country. For example, you are finding the Cabinet Secretary of Home, Cabinet Secretary of Defense. So what they are doing, Cabinet Secretary for Finance at the Union Government level. So it ensures the administrative machinery functions uniformly across the country. And the relation between during emergencies, the balance of power between union and state government can shift significantly during emergencies, as outlined in Articles 352, 356, and 360 of the Constitution. For example, during the national emergency, for example, if central government announces emergency in the country, we have seen such kind of emergency importantly in 1970s. During the national emergency, the central government can direct the state governments on any subject, including those under the state list. Because you are aware of the state list, there are some matters listed in the state list. State government will have powers. But in times of emergency, the central government can direct the state government on any subject, including those under the state list also, thereby centralizing the authority. And you might have heard about president rule also. Sometimes the president rule will be imposed by union government in some of the states. We have seen in the history. If a state government is unable to function according to the constitutional provisions, for example, if the state government unable to safeguard the constitutional provision, if it is unable to function according to the constitutional provisions, the president can assume the powers of the state government. This provision has been criticized for its social misuse, but is intended to maintain the constitutional framework. This is about the presidential rule, and it relates to Article 356. If the state government fails to function according to the constitutional provision, president can assume the powers of the state government. Sometimes you will find financial emergency also. Article 360 relates to financial emergency. During the financial emergency, the central government can direct the state government to observe financial propriety and reduce the salaries of state employees and including judges also. For example, if the present central government announces a financial emergency, then state governments also have to follow that financial emergency. They are required to reduce their expenditure. They are required to reduce the salaries of the employees, including judges also. So the Article 360 states about financial emergency. The next one, administrative relations between the center and states. In one of the PPTs, just I have provided all the articles related to shows the relation between central government and state government. As I mentioned earlier, the administrative relation between the center and states are outlined in Part 11 of the Constitution under Articles 256 to 263. As I mentioned earlier, these articles I mentioned 256 to 263, which are outlined in Part 11 of the Indian Constitution as far as the relation between union government and state government. Article 256 mandates the executive power of every state should be exercised in such a manner as to ensure compliance with the laws made by the parliament and any existing laws that applies in the state. Simply you remember obligations of states and union. Article 256 states about obligation of states and union. Next, Article 257 states control of union over the states in certain cases. Control of union over states in certain cases. That is Article 257. For example, you can observe, union government is empowered to issue directions to the state. Central government can issue directions to the state on matters related to railway protection within the state. So state governments are required to protect the railway properties also. The Article 257 states about the empowerment, union government empowerment to issue directions to a state on matters related to railway protection within the state and construction and maintenance of means of communication declared to be national or military importance. So, in case of military importance or national importance, the central government is empowered to issue directives to states with regard to construction and maintenance of means of communication and at the same time railway protection within the state also. Next, Article 258 deals with delegation of union functions to state. For example, Article 258 empowers the President of India to delegate executive functions of the union to state governments or their officers. So the President delegate executive functions of the union to state government. So union government executive powers will be delegated to state government by the President according to Article 258. Next, Article 258A, delegation of state functions to union. Before that, I have mentioned about Article 258, the delegate the executive functions of union to states, but Article 258A deals with delegation of state functions to union. State functions to union. Next one, Article 260 allows the union government to exercise executive, legislative, and judicial functions in any territory outside India. Once again, I repeat, Article 260 allows the union government to exercise executive functions, legislative functions, and judiciary functions in any state, in any territory, the outside India, in agreement with the government of the territory. Next, Article 261 mandates full faith and credit should be given to public acts. You are finding a number of public acts. The public acts, records, and judicial proceedings of union and every state throughout the territory of India. So it mandates full faith and credit should be given to public acts. We have to give full faith and credit to public acts, records, and judicial proceedings of union government and every state government throughout the territory of India. Article 262 relates to adjudication of disputes relating to waters of interstate rivers. Water dispute between the states are a crucial area of contention in India. At the beginning also, so the water dispute is a critical area of contention in India. So Article 262 empowers Parliament to provide for the adjudication of disputes related to waters of interstate rivers or river valleys. Article 263 empowers the President of India to establish interstate council. At the beginning also I mentioned, President can set up interstate council according to Article 263. So these are the different articles related to the relation between the central government and state government as far as the administrative matters are concerned. Now, some of the precedents, that is some of the cases that was the judgments given by Supreme Court of India. In the case of Rameswar Varan versus State of Bihar, it was observed it is mandatory for the state government to act accordingly to the direction by the central government. So from this judgment, it is a judgment from the apex court, that is Supreme Court. You can understand the important role of the union government. It is mandatory for the state government to act according to the directions issued by the central government. In the case of State of Karnataka versus Union of India in 1977, this is one of the judgments from Supreme Court of India. It was held, center can issue directions to a state. Now union government, central government can issue directions to the state under Article 256 as a legal entity. So union government can give directions to state government under Article 256 as a legal entity, not as a geographical or territorial unit. There was one more case. This is the judgment, one of the judgments by Supreme Court of India. In the state of Rajasthan versus Union of India, the apex court, that is Supreme Court, held that the issuance of directions to state government by the center is justified. So in the before judgment also I mentioned that Union government has issued certain directions to state government in 1977. So the Supreme Court of India, as per the Supreme Court of India, issuance of directions to state government by the center under Article 256 is justified if the union government is of the opinion that the manner in which the executive powers of the state government is exercised may be contravention to the enforcement of central laws. In Swaraj Abhiyan versus Union of India, the apex court, Supreme Court, drew attention to this provision, calling it a forgotten provision. This is because of the seldom usage of this provision since the Constitution came into the force. So from this you can understand the executive powers of the union government. So sometimes all the directions of the union government are highly justified, and at the same time the union government can issue directions to the state government under Article 256, and at the end measures to strengthen the relations. So how to strengthen the relation between the union government and state government with regard to administrative matters? Strengthening cooperative by reducing the central overreach. So we have to promote cooperative federalism. That cooperative federalism, by reducing the central outreach, would enhance the relation between the central government and state government. And as the previous speaker, Mr. Mohit Saini, he also mentioned about reforming the role of the governor to ensure neutrality. That step also would enhance the between the central government and state government. So role of we have to reform the role of the governor to ensure neutrality, and we have to promote fiscal federalism with more untied funds for the states. Fiscal federalism is to be promoted, as I mentioned earlier. Cooperative federalism. Number 2, the reforming the role of the governor to ensure neutrality and fiscal federalism, and we have to streamline the judicial mechanism for dispute resolution. So for dispute resolutions, we have to streamline the judicial machinery, and we have to strengthen the interstate council. This is one of the institutions. Interstate councils also have to be strengthened. We have to promote mutual delegation of administrative functions between the union government and state government. At the same time, make full use of constitutional provisions like Article 258, which allows the president to delegate union functions to states. So we have to make full use of constitutional provision like Article 258. It allows the President of India to delegate union functions to states and vice versa for more efficient administration. And there is a need to resolve central state disputes also. And we have to consider further decentralization by introducing a local government list within the 7th schedule of the Constitution. You know that we have union state list. Now you are expecting local government list also within the 7th schedule, and we have to recognize the states as a center of innovation. We have to recognize the states as a center of innovation and involve them more in the policy making process. Because see, here one of the major criticism of the Planning Commission is only all the decisions were taken at the all the decisions are centralized at the time. So keeping in mind only Niti Aayog was formulated. No, state governments are also, they are involving state governments also in the policy making. So then only the disputes between the central government and state government can be avoided to some extent. To sum up, the aim of the Indian Constitution is to establish either collaborative or cooperative federalism through the division of powers between the union government and state government. a certain autonomy should be given to the state governments. State governments should have some autonomy to ensure that the administration at the grassroots level remains efficient. So some autonomy should be given to state governments. Simultaneously, state government also should exercise some powers over the states to maintain a balance. States should be given autonomy, just I told, and for the central government also should exercise some power over the states to maintain a balance. So healthy debate and discussions between the central government and state government is crucial for the maintenance of federalism. Within this, I stop my presentation. I thank Sakshi Education, the in charge of Sakshi Education, Mr. Chaitanya Kranti.